All rise. The High Court of Shah Alam is now in session. Judge Mohammad Arif presiding.
Good morning, ladies and gentlemen. Today, this honorable court will hear the case of Maxwell, John Gray, and Shun. Please be seated.
My lord, this case concerns the issue of inheritance of a house owned by the deceased, Corey John Gray, who is a New Zealand national. The plaintiff in this case, Mr. Maxwell John Gray, is the administrator of the deceased estate, while the defendant, Mrs. Siew Shun, is the deceased wife. Both the plaintiff and the defendant are assembled by their respective counsel.
Thank you. Are all the parties present?
Yes, my lord. My name is Hasya, and I am representing on behalf of the plaintiff, Mr. Maxwell John Gray.
Yes, my lord. I am Fatima, the representative for the defendant, Ms. Shun.
Mrs. Nurafrina, please swear in the jury.
Please raise your right hand. Do you solemnly swear or affirm that you will fairly try the case before this court and that you will return a true verdict according to the evidence and the instructions of the court? Please say I do.
We shall now begin the hearing. Counsel may proceed.
Thank you, my lord. Ladies and gentlemen, I will first present my case on behalf of the plaintiff. The plaintiff was the executor of the estate of Corey John Gray, the deceased. He had intended to sell a house owned by the deceased, but the defendant had refused to agree to the plaintiff's request for vacant possession of the said house. Consequently, the plaintiff filed an originating summons seeking for an order of summary vacant possession of the said house to this court. I would like to call upon the plaintiff to justify his claim.
Please raise your right hand. Mr. Maxwell John Gray, do you promise that the testimony you shall give in the case before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Mr. Gray, please introduce yourself and brief to the court how you became the administrator of the estate owned by Corey John Gray.
My name is Maxwell John Gray. I am the father of the deceased. The deceased declared in his will that once he passed away, all his estate will be handled by me. That is how I became the administrator of his estate.
You came here today to file an originating summons seeking for an order of vacant possession of the said house. Is this fact correct?
Yes, I am.
Why do you need this order from the court?
I request an order from the court because I need to sell the house, but the defendant and her son was living there without my consent. I also repeatedly request and demand them to leave the house, but they refused to accede my request.
Why do you need to sell the said house?
The repayment of the loan financing the purchase of the said house is paid up by the deceased. Since the house is depleting and as the installment payments become unaffordable, therefore I need to sell the house.
Mr. Gray, do you make any request to the defendant to leave the house?
Yes, I have requested and demanded the defendant to leave the house several times. However, they still refuse to follow my request. And now I am right here filling the application.
The defendant claimed that she is the wife of the deceased, which makes her entitled to live in the said house. So why are you disagreed with her claim?
I disagreed because the defendant cannot claim to be the wife of my son. It is because the purported marriage between the defendant and the deceased was purely customary and was never registered in accordance with the law of Malaysia or elsewhere.
Did you know the deceased had a child with the defendant?
No, I do not know. I only acknowledged about his child from his previous marriage. As for the child that he had together with the defendant, he never once mentioned about it. I only know about it when I tried to retrieve the house. Besides, I even doubt whether the child is a biological son of the deceased.
Thank you. I have no further questions for the plaintiff.
Does the defense have any questions?
Yes, I do.
Please proceed.
Mr. Maxwell, do you refuse to accept the fact that the defendant is the wife of the deceased due to her race?
Objection, my lord. The question is irrelevant to this case.
I accept your objection. Counsel, please rephrase your question.
Mr. Gray, is there any particular reason on why you refuse to believe that my client is the wife of the deceased other than your ignorance?
In my eyes, they are not a married couple, and I have no knowledge about their marriage. They got married through customary marriage, which provided no proof or document of their relationship. The fact that there is no legal proof of their marriage is already enough for me to excuse her claim. And I believe, in the eyes of the law, the marriage is invalid.
I have no further question, my lord.
Counsel, on behalf of the defendant, please proceed with the case.
Thank you, my lord. Ladies and gentlemen, my client is here today to defend herself from the order of vacant possession of the said house. I will now call upon Ms. Lim Siew Shun for further justification of her claims.
Please stand. Raise your right hand. Mrs. Lim Siew Shun, do you promise that the testimony you shall give in the case before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name.
My name is Lim Siew Shun.
You may be seated.
Ms. Lim Siew Shun, why did you refuse to leave the house?
I refuse to leave the house because I am the deceased wife, and this child is his biological child. So my son and I are beneficiaries of the deceased estate, which includes the said house. I am also entitled to the house because I had paid the initial deposit of the house amounting 13,440 ringgit.
Can you provide any justifications for your claims?
Firstly, the will is written 2 years after our marriage, or to be exact, after our child was born. In the said will, it is mentioned in clause 3. I give all my personal chattels, including motor vehicles, equally for those my children who survive me. It is true that the deceased only has one child from his previous marriage. But then, we are blessed with another child after our marriage. As the word children in clause 3 means more than one child, so my son is included. This is my right to live in the house. As for me, maybe the plaintiff disagrees I live there because I am not a legitimate wife, but I have also made payment for the house. Therefore, the house is supposed to be my belonging as well. So why do I need to move out from my own property?
Do you buy the house together after getting married?
Yes, getting married through custom does not stop us from living just like other married couples.
Mrs. Lim Siew Shun, regarding the initial payment, are you suggesting that the upfront payment of the house is paid with your own money only?
After negotiating with my husband, we agreed that I would pay for the initial payment. So yes, he was not involved.
Then the payment must be made using your personal bank account, right?
Yes, it is true.
With that, my lord, I would like to submit this document as the first evidence to support the defendant's claim. This is the defendant's personal bank check issued by Afiq Bank for the initial payment of the said house.
Objection, my lord. I would like to argue that the amount of payment made by the defendant does not coincide with the amount of payment stated in the sales and purchase agreement entered between the deceased and the vendor. Therefore, I would like to submit another piece of evidence on behalf of the plaintiff to refute the defendant's claim. Please accept my submission, my lord.
Alright, counsel, please review your submitted evidence.
Thank you, my lord. According to the sales and purchase agreement, the upfront payment of the house must be 10% of the purchase price of the house. Since the purchase price indicated on the agreement was 448,000 ringgit, the amount of the amount of deposit that should be paid by the defendant was not 13,400 ringgit, but 44,800 ringgit. My lord, if the defendant only paid 13,400 ringgit, then the balance for the payment would be covered by the person whose name in the agreement, which was the deceased. Therefore, the defendant's claim, whereas she was the only one who paid for the initial payment, is not true. That's all from me.
Does the defendant have other evidence to refute?
No, my lord, and no more questions from defense.
Counsel, you may proceed.
Did both of you pay for the house loan together?
Objection. The question asked is not relevant or related at all.
My lord, the defendant claimed that she has the right to inherit the house because she is the wife and she pays for the house as well. We have identified that her first claim is invalid because the marriage itself is invalid. As for the second claim, she must prove that she really pays for the house. This is because only paying for the upfront does not make one the owner of the house. May I proceed, my lord?
Defendant, please answer the question.
No, he paid for it alone.
So, you were not able to pay the upfront payment fully and you did not pay for the house loan too, yet you said you paid for the house.
But my name was included in the application for the house loan. So actually, I have the right to the house.
Miss Lim Siew Shun, do you have any proof to support your statement?
Miss Lawyer, do I sound as if I made this up?
I have no further questions, but I would like to call upon a witness to testify to the fact given by the defendant just now. May I, Your Honor? May I, my lord?
Yes, counsel, you may call your witness.
Thank you, my lord. I call to the stand Miss Filzah.
Witness, please stand to be sworn in by the clerk.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Please state your name and your occupation for the court.
My name is Filzah and I work as a banker at the Afiq Bank, Puchong branch since 2013.
Mrs. Filzah, are you the one in charge when the deceased wanted to apply for a loan?
Yes, I am.
Could you please explain the situation at that time?
Sure. The deceased and his wife, Mrs. Lim Siew Shun, had previously applied for a loan to purchase a house. It is easier for the defendant to apply for the loan as she is a Malaysian rather than the husband who is a New Zealander. However, she is unemployed. In order to qualify for a loan, she needs to provide several documents like payslips, which she does not have. For a solution, we advise Mr. John Gray, the husband, to apply for the loan instead of his wife. The deceased may declare the defendant as a co-owner of the said house, if he wanted to.
So, the defendant gave a false statement earlier, am I correct?
Yes.
Thank you. I have no further questions.
Defense, do you want to cross-examine the witness?
Yes, my lord. Miss Filzah, may I know what is the defendant's status towards the house?
Well, she was neither the borrower of the house loan nor the owner of the house. And I remember that she was not the co-owner of the house as well.
Then, does it mean the defendant was not eligible to be the co-owner as well?
No, she was eligible, and I did advise the deceased to register the defendant names as the co-owner so that she might get benefit from the house, but the deceased refused my suggestion.
Refuse? Could you please explain the term refuse and why he refused?
I do not know his real intention at that time, since I am just a banker who managed his loan application process. To add, he did not tell me anything concerning this matter, as it is none of my business. So why would I ask him? It is his personal matter, right? But I'm sure enough that I already gave him the suggestion to register the defendant names as the co-owner of the said house. It is up to him, but then he refused to accept my suggestion. Therefore, I respect his decision.
Thank you. I have no further questions.
You may be dismissed. Any further witnesses?
No, my lord.
No, my lord.
Counsel for the plaintiff will now present their final argument. Counsel, you may begin.
My lord, ladies and gentlemen, to conclude my submission, there is no such benefit from marriage claimed by the defendant because of illegitimate and invalid marriage due to no proof and evidence that the defendant had married with the deceased. The child born by the defendant also cannot receive any benefit since the child was born out of wedlock. Next, the sale and purchase agreement also cannot be considered as a deposit by the defendant due to insufficient amount deposited. Therefore, the defendant had no entitlement towards the house. Thus, they need to follow the vacant possession notice.
Counsel for the defendant, you may continue with your closing argument.
Thank you, my lord. My lord, ladies and gentlemen of the jury, my client has raised defense under two reasonable claims. First, she is the wife of the deceased and her son is named as the inheritor of the deceased property. Next, she also claims that she has contributed in paying for the house as well. As her representative, I hope the court will consider her position and contribution for the house while making judgment.
Thank you, defendant. Ladies and gentlemen of the jury, I'm now going to read my judgment regarding this case. After examining the testimony of witnesses and the evidence presented from both parties, this court asserts that the marriage between the deceased and the defendant is not valid by law. In other words, the customary marriage claimed by the defendant was not recognized by law. The defendant was not entitled to any benefits from the deceased estate. Additionally, the child was born out of wedlock and was not an illegitimate child since this customary marriage was not registered, hence not recognized by law. Therefore, the child did not have any right to the deceased estate. Secondly, the sum to be paid on the day of the execution of the offer to purchase must be 10% of the purchase price, which is 44,800, and not the amount that the defendant has paid, which is 30,440. The court determined that the defendant's claim of paying the initial deposit toward the purchase of the house was bare and unfounded. Likewise, if the debt had intended to include the defendant's and her son's name in the will, the deceased would have do so. However, this did not take place. Therefore, the court concluded that the defendant had established no triable issues in order to reject the plaintiff's right to an order under Order 89 of the Rule of Court. The jury is thanked and excused. Court is adjourned.